conflict of interest potential exists in all committees. I know that when you bring a bill into another committee that you have, you actually go out and present the bill and then you stay out there and don't discuss it. I know that typically, at least I believe typically, when it gets to the exec time, you come back in and actually vote on your bill. In my case, I've agreed to completely stay away from the Johnson case and not be actively involved in any way on the Johnson case. And when we get to talking about just what we want for further information, having the Vice Chairman do everything, and I will probably walk out of this area to sit over there just for appearances. But in the future, if you're a sponsor of a bill, let's plan to do it that way for everyone. If you're a sponsor of a petition, rather, if you're going to bring a petition and then plan to not be involved in any way, just you'll present it, and then the committee will take care of it. We'll probably try to replace it or something like that. It would still be worked out, but that would be my idea of the better way, the best way to do it.
The other concern I have, looking at the petitions procedure, if that's what we're discussing, is that at least two of the appropriate remedies listed under number 8 appear to me to be remedies that the legislature cannot actually accomplish. So we are including in our procedure remedies already outside our purview. Those being recommendations for removal of public official, which is certainly the legislature can do that, but they can only do it by address or by impeachment. And there are constitutional provisions for how that happens, and it's certainly within the legislature's purview, but that's what has to happen there. And the other is recommendation of invalidation of prior decision or order, and the legislature does not have the ability to do that. They certainly can prospectively change the laws.
Let me tell you where the deficiencies are. And I mean, I take all the credit, so to speak, for that. We are limited in what we can offer. When they come in with a remedy that's not legislative, it shouldn't be in the petition. And I've made a point of making provisions in the future. On the other hand, they've asked for several that are actually legitimate to us, and so on. So, yeah.
But may I respectfully request that it behooves this committee to not incorporate into its rules something which we are not actually authorized to do.
I agree, yes. Okay. I agree.
I'd like to see, when we have a grievance, I'd like to see the other party notified. Because I don't think some of the women have been notified that we were holding these hearings.
I agree with Representative Lindsay and Representative Weber that we really need to be clearly, when we're hearing these petitions, what we can do, what our role is, what our responsibility is, and what our rights are, what we can do. So I feel like I'm kind of in the dark, just shooting here, not knowing exactly what we're doing or what our procedure is or what we can do.
When we finally make a decision on a petition, say if it's in favor of the petition, what happens next? I mean, what's the next step if this person actually convinces us, saying that we agree with this person? What's the next step? What do we do after that?
Well, it has to be legislative. I thought we went all through that, but the legislative part is anybody can bring a bill, bring a impeachment, it winds up in the categories of bills, house orders, or whatever, the things we can do, resolution.
When this person says, when we agree with whoever this person is finding, are we going to write a bill at that time? I mean,
that would be what we, our job, if you look at the paperwork, well, you have a procedures thing that I've given you, and it shows you when we get down, there's a list toward the bottom, I have it here, where it says what our power is to recommend, what we do in the executive session, we find the grievance founded, we find it founded with committee recommendations, or we find the grievance unfounded. Committee recommendations will be limited to saying that a correction is going to be made to the laws relating to such and such.
We're gonna make legislature change specific law, or we're gonna make the legislature to agree with the person who submitted the petition.
We're not making anything. We're just making recommendations.
All right, it's a recommendation.
if we do it at all. We're not bound to do any of that stuff. We can sit here and just chat about it and say, I don't see anything we can do or whatever. I mean, but we've come to a conclusion that would say grievance is founded or not founded.
Right.
We can stop there.
I don't wanna sound, I am a little confused because I don't know what the end result is if we agree with a person to move forward. I don't understand the next step.
That, our step is to say it's founded or unfounded.
And we submit that to legislature?
And we can, as a committee, or as individual members of the committee, or the sponsor himself, or whatever, could then bring a bill or whatever other option the legislature itself has.
All right.
We're a recommending committee, not a, yeah.
Someone help me out here?
If this committee determines that a complaint, obviously, if it determines that a complaint is unfounded, that's fairly clear. But it says in the rules that the recommendations are then made to the House. So am I understanding that the House then votes on those recommendations, and after that, then any individual member may do what any individual member already has the right to do, which is go to OLS and ask for whichever action they want to do. But the House will vote on a recommendation that this committee makes, although it will not be actually taking any action.
That's my understanding, and that's not exactly clear, frankly, to me. But I believe, we have a previous one we found unfounded, and I said to Karen, and this is all in a discussion mode right now, this first one we have to deal with, they said, so we have our founding grievance and unfounded, and I want to put together a blurb and put it in the calendar, and she said, well, what for? Is there gonna be a vote on it? And that's where we are. I mean, actually, we're trying to sort this out, so, I can't
So
even begin.
am I clear that we don't know what happens once the committee makes a recommendation, except that we have
That's
a
correct.
petitions procedure here, which says that we will make those recommendations to the House.
Right.
So we either need to follow the procedure or change the procedure.
We have to make the recommendations, we have to find out at this point, and then but you know, the rules, I admit that the rules are in flux, so it's not gonna be silly for me to pretend otherwise. We're trying to sort something out that actually works, so that we actually are in a position to listen to people and we suggest something somewhere, or do something, I wanna recommend or not, whatever. But yes, Paul, yeah. How it ends with the House.
May I just say that I'm very anxious about a process in which the rules have not been determined yet. The rules are in flux. The rules that I see written down are not being followed, and we are already in the process of having heard some of these petitions without having had any rules for what we're doing or why, or what the outcome is going to be, and what is acceptable, you know, under our Constitution, under our statutes, under our form of government, under anything. That's my global concern, and actually the reason that I had my hand up to begin with was a more specific concern arising out of the issue of giving notice, where on the one hand, I think that if we're discussing a situation that impacts either a government agency or an individual, obviously they should be given notice, and in the case of a government agency, they're used to coming over here and explaining to us regularly what they do, as is entirely appropriate. But in the case of an individual, has there been any consideration of what it must be like for a private citizen to get a notice, the form of which I don't know and haven't seen, informing them that they are to be the subject of an investigation by the general court, and they should come and talk to us about some aspect of their very personal or private life? I mean, has anybody given any thought to what that must be like for an individual to get whatever notice you send out?
Mr. Chair.
Well, if I may just, on that particular issue, supposing DCOIS does the very same thing and aggrieves a person because they were falsely accused, that person comes before this committee and says, look, these people brand me and wrecked my family, and the courts have wrecked my family. They have that. The whole purpose of this committee is to say, listen, we want an investigation, or we want to remedy this by introducing legislation to protect the citizens. I think bringing these people in, allowing them to have an opportunity to have a voice, allows us to say, look, okay, anybody have any ideas? Anybody have any legislation? Should there be an investigation instead of just hearing what DCYS has to say? And I'm not picking on DCYS, I'm just saying here's an agency which has a potential of being an abuse of power. That is what my understanding of what's going on.
And if I may just follow up, because I understand that point of it. My concern is some of these petitions ask for a change of custody of a child, which first of all, we can't do. And secondly, I just want to know as a matter of knowledge, has this committee then sent a notice with a copy of this petition to the other private party, not to the agency, which may or may not have used agency discretion, but, you know, if Mr. Smith comes in and says, custody was wrongfully taken away from me, which it may or may not have been, is Mrs. Smith, an individual, sent a copy of this petition in the mail and told that the legislature may be changing custody of her child? I mean, that seems to me.
Well, first of all, you know the answer to both those questions, so.
No, I don't, I'm
I'm not saying
actually
that.
answering a
That's not what we
I'm
said.
asking a genuine question, because it says that we're sending notice to the other party, and if
It
that's.
says name, I believe it says name parties, and that's what's happened so far. What we do here, people come here and they, as Representative Morgan says, they vent, and he knows that, going back to the day we were meeting in the other building, the same people, some of the same people that are here venting now, we're venting. They have no understanding of the separation of powers. They still persist in thinking that this legislature can overturn their custody decisions or their support orders. We know we can't, but they don't, so they come here and vent fine. But if at the end of that, we don't find that they have articulated a grounds for relief that the legislature can grant, then at that point the committee would presumably recommend to the House that it be, the grievance has no merit, that it should be dismissed. And no harm done, but it's only after we found something that we can deal with that we should at that point notify other people, so that the concern that Representative Weber pointed out would have been met. We wouldn't be just throwing out grenades all over the place with no basis for doing it. And other than just posting the notice we post for public hearings at any time, grievance of David Johnson, anybody wants to show up. But don't send any specific notice to anybody until we found that there's some reason to go forward with it. In court, there's a pleading called a demur, which is filed, which says basically everything the complainant says is true. There is no relief that can be granted by this court, and therefore we move to dismiss. So that's another parallel between what our rules should provide, so that there's a gatekeeping process that continues beyond the initial gatekeeping, function that you serve yourself, Mr. Chairman. The committee as a whole would have a further gatekeeping function of determining whether there's anything that this committee can really do, and if there's no ground found, if the petitioners don't articulate anything, the matter gets dismissed and we just move on. Were you recommending something a different class from unfounded, though? Did you say there would be another class of things? No, I think that's sufficient, but the grounds, of course, need to be stated why we agree it's unfounded. Yeah. Usually the reason would be they want us to do things that are just not within the competence of the legislative branch to do. Representative Weber?
I'm listening to this discussion as a new person in this committee, so, and I'm listening to Representative Lambert, and I quite agree with the argument about having a perspective, seeing a problem, and figuring out how to deal with it as a legislature. What I do not understand is why, what you're actually recommending, and what all of the people who have spoken have come to in the end, is that in the end, an individual legislator perceives a problem because they have seen a pattern over time of an issue that concerns them, and they go to OLS and they draft legislation which is then taken up by this House. That is what this House has done for the last 100 and nearly 200 years. And so I think that what we're coming back to is what we have done for all this period of time is precisely what the House has done. And yes, if there's a need to understand a particular function of a particular agency or gather information from people of a particular agency, we already have two ways to do that. You can introduce legislation. We have standing policy committees which deal with particular policy areas. You could create a study committee with a charge to study a particular problem, or you can simply introduce legislation that you think is effective to correct the problem. And given that we are sitting here talking about rules that we haven't done yet, to figure out how to confine people to appropriate remedies, talking about coaching people before they come to this committee so that they don't transgress either the boundaries of what we can do, and that's a simple matter for the chair of the committee to say, look, these are our rules, this is what we can do, this is what we can't do, you need to stop talking now. Telling parents what they can or cannot talk about in which forum with respect to their kids. I mean, I think that the committee as a whole is exacerbating a number of problems, and that the remedies you're looking for are already available to this legislature, and they've been pursued for years.
My main question is, are we doing a disservice to people by hearing it when we don't have a set of rules by where we're going? I'm coming in as an individual and saying that I tell you my personal, private, intimate stuff, and thinking that you are going to be able to do something for me, or at least you have an idea of what road you're going down, and I'm not sure we have that idea. I'm not sure.
It seems to me that we are doing the public a huge disservice, and we're also really doing the image of this legislature a huge disservice. If what is happening is you're continuing to schedule matters for hearing without agreeing what the ground rules are, and that includes some kind of notice, whether you call it guidelines or procedure or whatever, as to what this committee can and can't do. I mean, it seems to me that the cart has been put before the house, the horse. The committee needs to decide and agree among themselves what the committee is allowed to do by Constitution, and the committee needs to decide what the committee wants to focus on as a matter of legislative priority and what can be left to other committees. The committee needs to decide what remedies it can offer to people and tell people that first, so we are not continually, because I have seen this in the context of judiciary, and I know other people have seen it in the context of other committees, so that we are not having people invest huge amounts of time and effort to come and present to us a petition asking us to do something that's not in our power to do. They need to be told that up front, and the committee needs to decide as a matter of, first, constitutional provisions, what are we allowed to do? Secondly, as a matter of legislative priority, knowing that we only have so much time and so much energy and so much, financial ability to do things, what the committee's going to focus on, so that you can then say, as a matter of scheduling, which is certainly a matter for the chair, you haven't asked for anything that the committee does, that's one thing, or the committee has a procedure which Representative Sork has suggested, and which you've been talking about, but which isn't in a rule anywhere, so nobody knows what it is, of you're going to give a written statement to the committee of however long the committee agrees is appropriate, and the committee is going to review that before anybody stands up here and starts discussing stuff as to whether it's an appropriate thing to go on or not. But you need to decide that first and have hearings after.
That particular part is actually, it was adjusted in individual rules a couple weeks ago, about, y'all remember about, that we're asking for a 3-pager, so that's not a thing that's missing. It's not in yours, but you're looking at an old,
Well,
we are,
it would be very helpful then to be sure that every committee member has the current rules.
right, they're supposed to be providing that for me today, this afternoon. Representative Sork.
Thank you. Responding to that, I agree, it would have been great to have everything in place in advance, but the trouble is, as through experience, the committee has discovered where the deficiencies lie, and I just don't think there's any other way to discover some of these things except through experience. And it's true that some people have been here, and I'm sure a lot of us have sat here, and I haven't been here all the time either, so I'm in the position you are, where my knowledge of what's going on here is very complete. But sitting here listening, and I'm thinking, you know, maybe the judge was the most corrupt person in the world, and maybe he shouldn't have made the custody order, and maybe he shouldn't have done this and that, but there's nothing we can do about that. If somebody has gone to judgment, it's become a final judgment, that's it. All we can do deal with is the future. And they have been here apparently not realizing that, and no matter how many times the chairman has told them, it doesn't penetrate. So that's why I suggested the rule I did, so we can save them from that kind of.
Well, with due respect, the rules say that one of the appropriate remedies is recommendation of invalidation of prior decision or order, and that
That's been stricken in the new version.
absolutely inappropriate.
That's been
But then,
stricken. I understand.
at
You're
least
looking
the
at the old.
committee members need to have the new rules.
It's a process. I can't get there in 2 seconds, that can't be perfect in the first 2 seconds.
I absolutely agree with you that there is a risk when we restrict the funding in the court system and then make further and additional demands on it. However, the court system is designed, as I understand it, to be the implementer of the rules of the legislature and to be the custodians of balance and fairness. If, as part of that process, they are not open to disclosure of information about their procedures, about complaints of their officers, and about potential abuses within their system to this body, then they have improperly spent their money, and they need to be accountable to this body at all times. They are separate in their operation of individual decision, but they need to be accountable for whether or not they are even-handedly distributing justice. And if they are not, we should restrict every single nickel that they have. And if they want to do it for free, God bless us, everyone. But if they are not protecting our citizens, they should get nothing.